Okay, going live to read just the introductory sections of Chapter 18 of Criminal Procedure, the trial, and then all of the subsections that go along with it. I think there's 4. So let's get started. As we noted in Chapter 1, the trial has traditionally been viewed as the capstone of the criminal justice. The crown jewel that reflects most of the basic elements of the process. It is not surprising, therefore, that many of the Bill of Rights guarantees relating to the criminal justice process refer specifically to the trial. Materials in previous chapters explore the Supreme Court interpretation of several of those guarantees, which include the right to speedy trial, Chapter 12, the right to an impartial jury, Chapter 15, to a public trial discussed in various points in Chapter 16, comparing the public's right of access, and to the assistance of counsel, Chapters 5 and 17. The cases in this chapter deal with still other trial guarantees. 1, the presence of the defendant. Cases defining the defendant's constitutional right of presence tend to involve 3 different issues. First, the Sixth Amendment guarantees the defendant the right to be confronted with the witnesses against him. This aspect of the right is treated in the Bryant case, see Section 2. Second, the constitutional right of presence, although rooted to a large extent in the Confrontation Clause of the Sixth Amendment, also has a due process component, United States v. Gagnon in 1985. Accordingly, the right is not restricted to those parts of the trial in which the defendant is actually confronting witnesses or evidence against him. And the issue is presented as to what other aspects of the trial itself or proceedings relating to the trial fall within the scope of the defendant's right. Okay. The critical question here is whether the defendant's presence at the particular proceeding has a relation reasonably substantial to the fullness of his opportunity to defend against the charge, Gagnon. As the proceeding is not directly a part of the trial, the court tends to focus on the context of the particular case in answering that question. See Kentucky v. Stinser, which was heard in 1987. In parens, it says the judge's in-chambers examination of 2 young victims of alleged sex offense to determine solely whether they were competent to testify did not constitutionally require defendant's presence, where defense counsel participated, and further questions concerning competency could be raised at trial with defendant present. So, another major issue presented in defining defendant's right of presence is what conditions permissibly can attach to that right so that a defense failure to comply with those conditions results in the loss of a right. And that comes from Illinois v. Allen. The single case in Section 1 deals with this issue. Prior to Allen, Taylor v. United States, the court had held that a defendant cannot complain of her if he voluntarily absents himself during a trial and the court continues the trial. Excuse me. Through to verdict. The court has not had occasion to rule on the state's authority to proceed to trial in defendant's absence where the defendant was not even present at the commencement of the trial. So, Illinois v. Allen starts on page 976. We'll return to that. But we're going to skip through. Michigan v. Bryant is on page 980. But the introduction to that case is subpart 2 of this chapter, Confrontation and Compulsory Process. The Supreme Court has characterized its cases dealing with the Sixth Amendment's Confrontation Clause as falling into 2 broad, albeit not exclusive categories: cases involving the admission of out-of-court statements and cases involving restrictions imposed by law or by the trial court on the scope of cross-examination. Kentucky v. Stinser, 1987. The first 2 cases in this section fall within the first grouping, while the third case falls within the second grouping. The cases in the first grouping generally have involved the constitutionality of admitting into evidence hearsay, that is, a statement that was made out of court and is being offered in evidence to prove the truth of the statements asserted in that statement. Under the rules of evidence currently applied in the different states as at common law, most hearsay testimony is not admissible in evidence, but there are exceptions. Certain types of out-of-court statements are classified as not truly hearsay, as measured by the primary functions of hearsay ban. Right, so let's just talk about that first exception. Certain types of out-of-court statements are classified as not truly hearsay, as measured by the primary functions of the hearsay ban, and others are viewed as within special exceptions to the ban that support their admissibility. Confrontation clause concerns obviously arise when the state, under one rationale or another, allows a prosecution witness to testify to a hearsay statement made by a third party. Here, only the witness is before the defendant and subject to cross-examination, not the third party, the hearsay declarant, whose statement is being used to prove the truth of its contents. The first case in this section, Michigan v. Bryant, is one of a series of closely divided cases redefining the relationship of the confrontation clause to hearsay exceptions recognized under state law. The opinions here present, the justices' ongoing disagreement about the scope of the Sixth Amendment commands and traces developments since the court replaced its earlier approach based upon the reliability of statements with one based on whether the statements are testimonial. Richardson v. March. The second case considers the question of the proper interpretation of the confrontation clause's bar against admissibility in the context of a joint trial where the confrontation clause bars admission of a confession against one co-defendant but not the other. Davis v. Alaska. The third case falls into the second grouping of confrontation clause cases. Those cases concerned with the restriction of cross-examination opportunity by law or by a trial court ruling. Davis should be read in light of the Pennsylvania v. Ritchie, previously included in Chapter 13, on the duty to the Sixth Amendment's guarantee of compulsory process. The Supreme Court has had very little to say about the Sixth Amendment's compulsory process clause. The leading case applying this clause, Washington v. Texas in 1967, struck down a state rule that the court characterized as an absurdity, one that prohibited the defendant from introducing the testimony of an accomplice on his behalf, but allowed the prosecution to put on the stand accomplices who would testify in its favor. And citing C. Holmes v. South Carolina in Section 4. Again, Brian is coming up on page 980. Paging through that section. Let's see if there's any more cases that will be read subsequent to this recording. Looks like Richardson v. Marsh is here in the confrontation and compulsory process section, as well as Davis v. Alaska, which we read earlier. Hard to forget that case. The right to remain silent or testify is subpart 3 of this chapter. And the Fifth Amendment privilege against self-incrimination has been examined previously in the context of the investigatory process. See chapters 6, 7, and 8. And pretrial disclosure, see Chapter 13. In its application to the defendant at trial, the privilege has special meaning, for it confers on defendant a right not simply to refuse to respond to questioning, but to refuse to be placed on the stand where he can be subject to such questioning. This right not to be called to testify, commonly described as defendant's right of silence, is a basic element of the accusatorial system of justice that requires the government to make its case through its own evidence and allows the accused to remain inactive and secure until the prosecution has taken up its burden, produce evidence and effected persuasion. And that is citing Taylor versus Kentucky of 1978. Griffin versus California, the first case in this section, is a leading case on the reach of this right of silence. The court there considers whether the Fifth Amendment requires that there be no adverse comment by trial judge or prosecutor on the defendant's exercise of that right. So that's really all it's about, is adverse comments by trial judge or prosecutor on the defendant's exercise of that right. The second case in the section, Rock v. Arkansas, makes the court's recognition of the constitutional right of the defendant to take the stand and testify, a practice that was not allowed at the time of the adoption of the Constitution. Rock also considers the appropriate scope of state authority to impose evidentiary limitations that restrict the defense exercise of this right to testify. So it's like the corollary right to defendant's right to take the stand and testify, and how much it can be restricted. Scope of the state authority to impose evidentiary limitations. Okay, that case starts on 1014 after Griffin v. California on page 1011. It's like due process requirements, part 4 of this chapter is on page 1020 and will be the last subpart of chapter 18 about the trial. The Supreme Court has long held that due process can be the source of trial rights not found in the more specific guarantees of the Sixth and Fifth Amendments. Holmes v. South Carolina examines constitutional protection for the defendant's opportunity to present a complete defense. Prosecution rooted in the due process clause as well as the computation and compulsory. Hello? Compulsory process clauses. Due process also imposes upon the state obligation to establish guilt beyond reasonable doubt. In Winship, 1970, from the requirement flows a series of related constitutional prerequisites. Taylor v. Kentucky considers whether one of these is a jury instruction on the premise of a presumption of innocence. Constitutional challenges to alleged prosecutorial misconduct at trial also are raised under the fundamental fairness standard of due process. Building upon the prosecutor's role as a representative of the state whose interest in criminal prosecution is not that it shall win the case, but that justice shall be done, Berger v. United States is the source of that quote from 1935. The court has recognized prosecutorial obligations to correct the material testimony of witnesses known to be false and disclose material exculpatory evidence within its control. That's for fundamental fairness standard of due process. See United States v. Bagley, the second case in the section, Darden v. Wainwright, considers application of the due process clause to the misconduct of a prosecutor in presenting the state's closing argument. Which really can't be like extremely inflammatory or inaccurate, which I'll just write in the margin here. Inflammatory or inaccurate, they're going to use more precise terms in that case. I'm just reviewing what I missed from filming. So the state has the obligation to establish guilt beyond a reasonable doubt from Henry Winship. Got it. And the requirement flows a series of related constitutional prerequisites. Whether one of these is a jury instruction on the presumption of innocence. Yeah, is that all right? Good question. All right, that's going to be it for chapter 18 about the trial. We're at 13 minutes. My phone's not ringing, so I might just keep going to chapter 19, retrials. And this is going to be about a 60-page chapter, but the main section is the same offense limitation, and the second section of it is aborted proceedings, followed by re-prosecution, post-acquittal conviction, before going to chapter 20. So for retrials, although it has some bearing on multiple punishments, the double jeopardy clause of the Fifth Amendment is concerned primarily with multiple trials. That concern extends to trials for both felonies and misdemeanors. The court concluded in its first major double jeopardy ruling that the reference in the double jeopardy clause to life and limb, when read against the common law background, was broad enough to encompass all criminal offenses without regard to the particular form of punishment that might be imposed. Ex parte Lange, 1873. The double jeopardy clause becomes applicable, however, only after the accused has been placed in jeopardy, and that does not occur until Romanet 1, the jury is impaneled and sworn in a case involving a jury trial. In Romanet 2, the first witness is sworn. This is when the right applies or arises. When the first witness is sworn in a case involving a bench trial. From Chris versus Breads in 1978. So then dismissals before jeopardy as attached, even where based on the ground that the prosecution's case is too weak to prevail, do not raise double jeopardy difficulty since the defendant has not been placed in jeopardy at the point of dismissal. A re-prosecution that results in a trial would not place him twice in jeopardy. Thus, double jeopardy does not bar returning a case to grand jury after it has refused to indict, refiling charges, and seeking a new preliminary hearing after the magistrate found a lack of probable cause the first hearing, or refiling charges after a trial court dismissed the initial charges on some pretrial objection, example, an insufficiency of the plea. That could be cured in a new indictment or information. So, too, where a trial court dismisses charges before trial on grounds that would bar re-prosecution, example, that the defendant had been denied his right to a speedy trial, no double jeopardy concerns are presented by allowing the state to appeal that dismissal and continue with the prosecution if it should win on appeal. The principles prescribed above are well established and fairly easy to apply. That is not true of all double jeopardy principles. Indeed, U.S. vs. D. Francesco in 1980, Justice Blackmun's opinion for the court, citing 21 double jeopardy cases decided by the court over the previous decade, acknowledged that the application of the double jeopardy bar has not proved to be facile or routine, and as demonstrated by the various changes in direction or in emphasis found in the court's rulings. The cases in this chapter deal with the most significant of those double jeopardy principles that have proved troublesome in their definition or application. So one is the same offense limitation, or subpart 1 of this chapter is the double jeopardy clause states that no person shall twice be put in jeopardy for the same offense. It is well established that common law prosecutions were not for the same offense where they involve the same statutory violation as to different victims, even when the violations occurred in the same incident. Ash v. Swenson. The first case in this section raises the question as to whether the double jeopardy bar places any limit on separate prosecutions in such situations. Ash, through its adoption of the collateral estoppel doctrine, imposes such a limit, but it is restricted to instances in which the first prosecution results in an acquittal, and that acquittal bears a special relationship to the offense charged in the second prosecution. At common law, separate prosecutions involving the same incident and the same victim could be for the same offense, even though alleging violations of different statutes. The second case in this section, U.S. v. Dixon, deals with the scope of the double jeopardy bar developed in this situation. Unlike the collateral estoppel doctrine of Ash, the limitation imposed here does not depend upon the first prosecution having been in an acquittal. It should be kept in mind the state law may impose limitations beyond those mandated in Ash and Dixon. Thus, some states require single prosecution for all offenses arising from the same transaction, as urged by Justice Brennan in his concurring opinion. Ash and other states largely follow the standard of Grady v. Corbin, overruled in Dixon. The second case in this section, Heath v. Alabama, deals with the possible applications of double jeopardy bar to multiple prosecutions by different sovereigns, which is generally okay. The position taken by the court here stands in contrast to the court's interpretation of the Fifth Amendment self-incrimination clause as extending to potential incrimination under the laws of a jurisdiction other than the compelling witness to testify. See Murphy v. Waterfront Commission. Discussing the Castigar opinion on earlier pages. Multiple prosecutions for basically the same criminal activity by different jurisdictions, example, 2 states or the federal government and a state, do occur but are in common. The overlap of prosecutorial authority is most likely to arise between the federal government and the state, and here non-constitutional limitations restrict multiple prosecutions. The internal regulation of the Justice Department bar federal prosecution following a state prosecution for substantially the same act, except upon the approval of the Assistant Attorney General, and many states have provisions that prohibit a state prosecution for any activity that has been the basis for a previous federal prosecution. But why? I don't know, it's weird that they'll apply this differently everywhere. In the last case in this section, Hudson v. U.S. turns from the combination of separate prosecutions under different criminal statutes to the combination of a criminal prosecution proceeding designed as civil, but which nonetheless may be seen as seeking to inflict punishment for this violation as criminal prosecution. The possible application of the double jeopardy bar to such a combination has great practical significance, as a wide range of criminal activity frequently leads not only to criminal prosecution, but also a civil proceeding brought by the government to gain a monetary property award that is equal to or exceeds what may be obtained as part of the criminal sentence or criminal fine or criminal forfeiture. So Ash starts on page 1041. Page through that to U.S. v. Dixon on page 48, 1048, and then that concludes on 1054. The dissent opinion continues on. Within talks about the Blockberger test. The Puerto Rico v. Sanchez Valley all on page 1063, and Hudson v. United States 1067 is all part of the same offense limitation. Now, border proceedings is section 2. The two cases in this section, Arizona v. Washington and Oregon v. Kennedy, set forth the basic double jeopardy standards applicable to re-prosecutions following a mistrial. A mistrial should be distinguished from the mid-trial dismissal, which is discussed in Scott in the next section. In contrast to dismissals of this type involved in Scott, a court ordering a mistrial does not find some fatal flaw in the prosecution that would present an absolute bar to conviction on the offense charge. Rather, the trial court rules that it would be inappropriate or impossible to continue with the trial and orders its termination without ending the prosecution. The judge ordered a mistrial assumes that a re-prosecution can be brought, but as Washington and Kennedy indicate, that is not always the case. So Arizona versus Washington on page 1074. And then Oregon versus Kennedy on 1079. Then we get to subpart 3, re-prosecution post-acquittal conviction. The double jeopardy clause was derived in large part from the common law plea of autrefois acquit, formerly acquitted, and autrefois convict, formerly convicted. And the two bedrock elements of the clause are that prohibitions against re-prosecution for the same offense following an acquittal or a conviction. It is here, however, more so than in any other area of double jeopardy jurisprudence, that the court has found the need to reevaluate applicable standards. In both the cases in the section, U.S. v. Scott and Burks v. United States, the court found it necessary to reassess the assumptions of earlier rulings. Scott raises a basic question of what type of ruling should be viewed as an acquittal. In particular, should a trial court dismissal that bars re-prosecution be viewed as an acquittal without regard to the grounding for the ruling? The fact that the ending of the case in Scott through dismissal came from a judge rather than a jury was not critical. The court had long held the acquittal rule applied to acquittals by judges as well as juries. A position reaffirmed in the case decided the same day as Scott, Santa Maria versus United States in 1978. Burks considers a proper scope of the Ball exception to the prohibition against re-prosecution following a conviction by allowing the re-prosecution whenever a conviction was successfully overturned on a defense challenge. The Ball exception had basically limited that prohibition to the situation in which the defendant was willing to abide by his conviction, i.e. bring a challenge, but the state desired to prosecute again in the hopes of either raising the charge or obtaining a higher sentence. Burt's recognized as an exception to the Ball exception, whereby the prohibition can have a bearing under limited circumstances, even where the defendant successfully challenges the conviction. So I don't know what that U.S. versus Scott and then Burks versus United States on page 1090. And it leads into the next chapter, 20, sentencing procedures.